pretty much since Caitlin Clark got assaulted in the very first damn game. We done seen countless attacks on Caitlin Clark, and I'm not even finna go through the jacket of playing the videos. We all know what happened at CC. Now, what is crazy about all of this is that the Wall Street Journal, wrote an article earlier this week kind of explaining Caitlin Clark's civil rights being broken. ESPN sports anchor himself, Stephen A. Smith, has spoken about the WNBA should be under investigation.
The story everyone else is missing just became crystal clear. While other channels are chasing rumors about FBI investigations that don't actually exist, I've been connecting the dots on something far more concrete and far more dangerous for the WNBA. There's a legal roadmap sitting in plain sight, and it leads directly from Dearica Hamby's courtroom victory to what could be the most devastating civil rights case in sports history. I'm Jackson Riley, and welcome back to the channel, where we filter out the noise and follow the digital breadcrumbs to the real story. Today, we're diving deep into the legal precedent that makes Caitlin Clark's situation an absolute nightmare for Commissioner Cathy Engelbert and the WNBA's legal team. If you're new here, make sure to subscribe because we're about to break down the legal blueprint that other creators are completely ignoring. Hit that notification bell because this analysis connects pieces that nobody else is putting together. Here's what we're covering today. First, the Dearica Hamby precedent that proves the WNBA is vulnerable to civil rights lawsuits. Second, how Hamby's successful legal strategy creates an exact roadmap for Clark's team. Third, the statistical evidence that makes Clark's case even stronger than Hamby's ever was. And finally, why the WNBA's silence isn't just bad PR anymore, it's potentially catastrophic legal exposure. Let's start with what happened to Dearica Hamby, because this is the foundation for everything that's coming next. In 2023, Dearica Hamby was traded from the Las Vegas Aces after announcing her pregnancy. What seemed like a simple roster move turned into a federal discrimination case that should have been a warning shot to every WNBA front office. Hamby didn't just complain to the media or hope for public sympathy. She filed a federal lawsuit, alleging pregnancy discrimination, hostile work environment, and retaliation. Here's the part that should terrify the WNBA. She won. In May 2024, Hamby reached a settlement with the Las Vegas Aces for $2.2 million. But more importantly than the money, the case established something that legal experts are calling a judicial precedent for workplace discrimination claims in professional women's basketball. The legal framework Hamby's team used wasn't complicated. They documented a pattern of differential treatment, hostile workplace conditions, and league inaction. They showed how pregnancy discrimination created an environment where Hamby couldn't perform her job safely and effectively. They proved that the WNBA, as the governing body, failed in its duty to protect players from discriminatory treatment. Sound familiar? Because reading through the legal documents, the parallels to Caitlin Clark's situation are absolutely stunning. Now, I've been filtering through the online conversation, and the temperature around Clark's treatment has reached a boiling point. The signals are pointing to something much bigger than basketball disagreements. We're looking at a systematic pattern that could make Hamby's case look like a warm-up. Let me walk you through the legal roadmap, step by step. First, establishing a pattern of differential treatment. Hamby's lawyers documented how she was treated, differently than other players in similar situations. With Clark, the evidence is overwhelming. According to statistical analysis from the 2024 WNBA season, Clark received 17.1% of all flagrant fouls, despite being just one of hundreds of players. The probability of this occurring randomly? According to data analysts, it's 0.21%. That's not basketball. That's evidence. But the statistical evidence gets even more damning. Chicago Sky players alone committed 11.8% of all flagrant fouls against Clark, specifically. When you can show that specific teams are disproportionately targeting one player with flagrant-level contact, you're building a discrimination case, not analyzing basketball strategy.
Let's talk about Caitlin Clark and the idea of a government probe or an investigation into hostile work environments being conducted by the government because of the actions that the league itself and some of the players have had towards Caitlin Clark.
The second element from Hamby's successful strategy: documented hostile workplace environment. This is where Sophie Cunningham's revelations become absolutely crucial. Cunningham, who's now Clark's teammate with the Indiana Fever, provided first-hand testimony about locker room discussions during her time with the Phoenix Mercury. She admitted that conversations often centered around how aggressively they should play against Clark and making her earn every inch of space on the floor. Official sources won't tell you this, but if you follow the digital breadcrumbs, a different picture emerges. These weren't casual game planning sessions. According to Cunningham's own words, they were strategic discussions about setting a physical tone early and sending a message. In employment law, when you can document coordinated workplace hostility, you're halfway to proving a hostile work environment claim. Rebecca Lobo, ESPN analyst and former WNBA star, initially dismissed targeting narratives, but has since acknowledged problematic officiating patterns. This represents a mainstream media credibility shift that legal teams call expert witness development. When respected analysts begin validating your claims, it strengthens your case exponentially. Third, league inaction and failure of duty of care. This is where Commissioner Cathy Engelbert's silence becomes legally dangerous. Hamby's case established that the WNBA has a duty to protect players from discriminatory treatment. When league officials fail to address documented patterns of harassment or differential treatment, they create legal liability. In Clark's case, the evidence of league inaction is overwhelming. Kennedy Carter's blindside hit, no ejection. Diamond DeShields' linebacker-style contact, no suspension. Marina Mabre's calculated shove, no fine. Tina Charles's back contact incident, not even acknowledged. Each non-response creates another piece of evidence for failure of duty of care. The Wall Street Journal's Sean McClain, a former White House staffer, published a piece arguing that Clark's treatment constitutes a hostile workplace and calling for federal investigation into potential civil rights violations. When former federal officials start using civil rights language, it signals that the legal foundation is solid enough for federal scrutiny. That brings us to the inevitable question: what's fact and what's speculation? Let's break it down. Here's what we know for certain. Dearica Hamby successfully sued the WNBA for $2.2 million using workplace discrimination law. The legal precedent exists. Clark's statistical targeting rate is documented at levels that would be virtually impossible to occur randomly. Player testimony confirms coordinated targeting discussions. The WNBA has consistently failed to discipline flagrant contact against Clark specifically. Now let's get into rumor territory. Nothing is officially confirmed, but the online chatter is too loud to ignore. Indiana Representative Jim Banks sent a formal letter to Commissioner Engelbert demanding answers about Clark's treatment and protection measures. This represents legitimate federal oversight inquiry, not criminal investigation, but it establishes government interest in the case. The temperature of the online conversation suggests something deeper is happening here. Stephen A. Smith suggested on ESPN that a Trump administration could leverage Clark's situation for political gain. comparing it to Columbia University's $221 million civil rights settlement. Smith's prediction shows how political weaponization could escalate this beyond sports into constitutional rights territory. But here's what the other channels missed completely, and it's the most important piece of this entire puzzle: the identity-based discrimination angle that could make Clark's case even stronger than Hamby's pregnancy discrimination claim. I've been reading the signals in WNBA social media and forum discussions, and there's an undercurrent that nobody wants to address directly. Caitlin Clark is a straight white woman in a league that is predominantly black and openly LGBTQ. Phonate paper, that shouldn't matter. In practice, it's becoming impossible to ignore. Former WNBA player Candace Wiggins spoke publicly in 2017 about being bullied out of the league for being straight. Her allegations were dismissed at the time, but they established a precedent for identity-based workplace harassment claims in the WNBA. The narrative increasingly frames Clark's treatment through an intersectional lens, and the legal implications are staggering. Workplace harassment laws don't just apply to office jobs. For professional athletes, the court is the workplace, and the league is the employer. If a pattern of harassment is based even in part on protected characteristics like race, sex, or sexual orientation, it becomes a federal civil rights issue. Combine Clark's statistical targeting rate with documented locker room discussions about coordinated physicality, add the league's failure to protect her, and include the potential identity-based discrimination angle, and you have the makings of a case that could dwarf Hamby's $2.2 million settlement. Legal experts I've been reading suggest that civil rights cases don't just look at intent, they examine impact. Even if the WNBA argues that Clark's treatment isn't intentionally discriminatory, the effect on her safety, career prospects, and work environment can still be grounds for federal action. That's where this gets really interesting, because I've been connecting some dots that reveal a potential strategic element nobody's talking about.
This thing is going to grow legs because a lot of people is going to speak out about this, and I'm telling y'all right now, people from behind the scenes sources have told me as a recent, now I wasn't gonna say nothing, that Caitlin Clark agent could possibly allegedly be behind this happening.
The speculation about Clark's agent potentially orchestrating federal attention is explosive, but it would actually be brilliant legal strategy. If Clark's representation team is building a discrimination case using Hamby's precedent, they would want maximum documentation of the WNBA's failure to protect her. Every uncalled foul, every ignored incident, every moment of league silence becomes evidence for their case. This would explain why Clark herself has remained relatively quiet about the targeting, while her support network, teammates, analysts, political figures, have been increasingly vocal. In discrimination law, you want to avoid the appearance that you're seeking special treatment while building evidence that you're being treated unequally. From an economic standpoint, the pressure on the WNBA is unprecedented. Clark's presence has generated a 380% increase in WNBA TikTok engagement, over 600% growth in merchandise sales, and television ratings that dwarf games without her participation. The league is essentially gambling with its most valuable economic asset while creating potential legal liability. If Clark's team follows Hamby's legal roadmap and wins a discrimination case, the financial impact could be catastrophic for the WNBA. We're not just talking about settlement money. Civil rights violations can trigger federal oversight, loss of broadcast privileges, and sponsor departures that would threaten the league's existence. The competitive intelligence here reveals something that other channels are missing entirely. While everyone else chases unverified FBI investigation claims, the real legal danger comes from established precedent and documented evidence. Hamby proved that WNBA discrimination cases can succeed in federal court. Clark's situation provides even stronger statistical evidence and broader pattern documentation. Looking at this through the lens of the narrative analysts who follow this channel, the metagame here is fascinating. The WNBA positioned itself as a league of empowerment and social progress. But if they're facing a successful civil rights lawsuit from their most visible player, it creates a contradiction that could destroy their brand positioning. The political, weaponization angle that Stephen A. Smith predicted is already beginning. Federal figures are asking questions. Media coverage is framing this as constitutional rights issues rather than sports officiating disputes. The longer the WNBA waits to address Clark's protection, the more ammunition they provide for discrimination claims. But here's what they missed that could change everything about the timeline. The Department of Justice doesn't need to launch. An investigation for civil rights claims to proceed. Private lawsuits using established precedent can move forward regardless of federal agency action. If Clark's team files discrimination claims using Hamby's legal framework, the WNBA would face discovery processes that could expose internal communications about Clark's treatment, targeting strategies, and officiating decisions. Imagine depositions where WNBA executives have to testify under oath about why Clark receives disproportionate targeting without disciplinary response. Picture team officials explaining locker room discussions about coordinated physicality. Consider referees answering questions about different officiating standards for different players. The discovery process alone could be devastating for the WNBA's reputation and competitive position. Corporate sponsors don't want to be associated with organizations facing civil rights lawsuits, regardless of eventual outcomes. And that brings us to the economic warfare aspect that reveals why this legal precedent creates such urgent pressure. Clark's economic impact on the WNBA has been unprecedented. Fever games now require larger venues to meet ticket demand. League Pass subscriptions have climbed to record levels. Merchandise featuring Clark's name and number has generated over 600% sales increases. She's proven that one player really can change the trajectory of an entire sport. The WNBA's failure to protect their most valuable economic asset while creating potential legal liability represents organizational negligence that goes beyond sports into business strategy territory. Every time Clark takes unnecessary contact without league response, they risk injury to their primary revenue driver while building evidence for discrimination claims. From a legal strategy standpoint, Clark's team would want maximum documentation of league inaction before filing any claims. The longer the WNBA allows targeting to continue without consequences, the stronger a discrimination case becomes. It's almost like they're building their own legal liability with every game. Now, I want to be transparent about something that's been developing in the online conversation. There are growing discussions about whether political figures might leverage Clark's situation for broader constitutional rights arguments. The combination of statistical evidence, economic impact, and identity-based discrimination angles creates a perfect storm for political weaponization. If a federal administration decided to champion Clark's civil rights as a campaign issue, the WNBA would face pressure unlike anything they've experienced. Political involvement transforms sports controversies into constitutional crises that can't be managed through normal public relations strategies. The temperature of the online conversation suggests this escalation is already beginning. Congressional letters represent the first stage of federal oversight. If political figures decide Clark's situation demonstrates broader discrimination issues, legislative hearings could follow. For the WNBA, the risk calculation has fundamentally changed. What started as officiating criticism has evolved into potential federal civil rights liability with unprecedented economic stakes. The Hamby precedent proves discrimination cases can succeed. Clark's statistical evidence and economic value make her case potentially explosive. The league now faces a choice between addressing Clark's protection immediately or allowing the legal and political pressure to build until external forces dictate the outcome. Based on the competitive intelligence I've been gathering, external pressure is accelerating faster than internal WNBA decision-making. That's what makes this legal roadmap so dangerous for the league's leadership. They're not just managing basketball controversies anymore. They're facing the potential for civil rights litigation that could reshape their entire organizational structure and competitive position. The question isn't whether Clark's team has legal options. Hamby's precedent proved those options exist and can succeed. The question is whether the WNBA will address their legal exposure before discrimination claims move from potential to filed. From everything I've been reading in the signals and following, through the digital breadcrumbs, the timeline for WNBA action is shrinking rapidly. Federal interest is growing. Media coverage is intensifying. Economic pressure is mounting. Legal precedent is established. The competitive landscape for WNBA content creation is about to shift dramatically because this story has moved beyond sports analysis into constitutional rights territory. Understanding the legal roadmap from Hamby's precedent to Clark's potential case provides the framework for analyzing everything that happens next. So, here's my question for you. Narrative analysts, do you think Clark's team is already building a discrimination case using Hamby's legal framework? Are we watching strategic legal preparation disguised as sports controversy? Drop your analysis in the comments because this meta-narrative is still developing. If this breakdown helped you understand the legal roadmap that other channels are missing, make sure to subscribe for more competitive intelligence analysis. Hit that notification bell because federal developments on this story are moving fast. Share this video with anyone who needs to understand the legal precedent behind Clark's situation, because the discrimination angle changes everything about how this story develops. Thanks for watching, and I'll see you in the next breakdown, where we continue following the digital breadcrumbs to the real story behind the story.